Welcome back. This is Attorney Patrick Silva. Imagine that you had one drink and you blew a .02, which indicates one drink, and you're arrested. What are you going to do about it? Well, this is a story about a Japanese man who was here in the United States on a valid work visa. He was working in the state of Michigan, and he's driving down the road one day, and it's after work, and he gets pulled over. He gets pulled over because one of his lights is burnt out. The officer approaches, says, "Hey, get out of the car." And of course, he doesn't speak perfect English, and he's talking to the officer. She pulls him out, and the officer administers some field sobriety tests. During the officer's conversation with her own dispatch, the officer saying, I don't know. Now she's saying she doesn't know if he's impaired, but later on she says, I really don't know what I'm doing. And this is all in dispatch logs. And I'll get the exact quote later on. I had some notes taken. But this was an appeal. And imagine you're the Mr. Akima. So you've been arrested, you get out, you do the field sobriety test, you blow a .02, and you're thinking, oh, okay, I'm good to go. Now he blew a .02 on what's known as a preliminary alcohol screening device, PAS, P-A-S. There's several different manufacturers. One of the most widely used one is an Alcosensor 4. It's made by Toximeter. Some use an Alcosensor 5. Some use a breath machine manufactured by Draeger. Draeger's a worldwide company. So he blows a .02 and he ends up getting arrested. Then the officer gets a search warrant for his blood, and his blood comes back at a .01. Now, this is where it's interesting. He blows an 02 and his blood's an 01, and the third digit was 4. So basically a .02 down to a .15, .015. That means he has the level of basically a drink in his system. What are you going to do? Well, like any good American citizen, which he's not, he hires a lawyer, and this happened, I think this was 2020, and soon thereafter he filed a lawsuit. Now, he's suing on the theory of false arrest, false imprisonment, and intentional infliction of emotional distress. When he's suing on false arrest, false imprisonment, he's claiming a Fourth Amendment violation. He's saying the officer did not have a right to arrest me, and what the officer did was wrong. With that said, the officer is going to have a defense, and the defense is, look, I'm a cop. I have something called qualified immunity, and it says that any reasonable officer in my same shoes would have done the same thing, and you would have been arrested. When Mr. Kima sued, it went to what's called the lower level district. The lower level district said, yep, Mr. Kima, you have the right to sue, and there's no qualified immunity for this officer. Well, what does the officer and her lawyers do? Well, they said, okay, we're going to appeal it to the next level. That's the Court of Appeals, and this would be in the 6th District because this was in Michigan area, Fowlerville. And if you Google it, you'll find the PDF on this court hearing. So they appeal it, and the Court of Appeals, I'll get to the short answer, said, you know what? Mr. Kima does have the right to sue. There's no qualified immunity. But then you have to say, what exactly is going on here? What is qualified immunity? And let's back up one. Did Mr. Akima even have the right to assert a Fourth Amendment violation? He's not a U.S. citizen. Well, the law is you don't have to be a U.S. citizen to have a Fourth Amendment right. When you're in this land, you have a Fourth Amendment right. You don't get treated differently just because you're not a U.S. citizen. And if you think about it, he was a highly regarded person in a high-tech industry working here. And he was on a work visa. And again, he was from Japan. When the courts looked at whether or not the officer had qualified immunity, they're going to look at what's called the totality of the circumstances. They're looking at everything that the officer did and what a reasonable officer in that same situation would have done. So we look at what's the very first thing that happened. The very first thing that happened was they pulled him over for the no headlight. When you think, is a headlight burnt out an indication that the person's driving impaired? Well, the answer is no. That's a mechanical violation. Usually an impaired driver is somebody that's weaving all over the road. They might have a crash into a parked car. I get a lot of those. They have a solo traffic collision, or they get pulled over because of weaving or speeding. But Mr. Akima didn't have any of that. Mr. Akima was just driving normally, and that's in the record. Driving fine, not speeding, not weaving. He just has a burnt out light bulb. That happens to anybody. So is that a legitimate stop? Yes, it is. So the reasonableness of the stop is valid, but is it reasonable on the probable cause that the officer have a right to arrest him? So they pull him out and they administer to Mr. Akima the field sobriety test. Now, they gave him the horizontal gaze nystagmus, that's the eye test. They gave him the walk and turn, that's the 9-step heel to toe, turn around, take 9 steps back. And then they had him stand on one leg like a flamingo and count to 30. So those are the 3 tests. At the end of that, they said, hey, you know what? Would you like to take a breath test? He says, sure. They asked him, how much have you been drinking? And he says, a little bit. He's honest. A little bit. I had a little bit of drink. So he blows into this breath machine. It's on the side of the road. It's a little handheld unit. He blows into it. Click. You hear the click, click, and you get a reading. And the officer gets a reading. And if, I have 2 of these breath machines. I have the Draeger and I have the Alcosensor 4. And these are pretty big numbers. And it says 0.02. And the reading, at least on my machines, they do not give a 3rd digit. And these are the same machine the officers have. So 0.02. Now, if you know anything about alcohol, 0.02 is way below the legal limit of 0.08. 0.08, 07, 06 down to 0.02. The officer also got a search warrant and took Mr. Akima's blood. Now, his blood came back at a 0.01. Now, as soon as they got the blood result back, and I think it was within a week and a half, 2 weeks, they dismissed the charges. So you think, all right, how are they going to get a DUI on Mr. Akima? There's 2 ways to get a DUI. You have what's called over the legal limit, over 0.08. And you have, if you're under 0.08, they try and get you what's called in Michigan, OWI, operating while intoxicated. And what they try to do is they say, let's look at his driving. Can we get him and show that his driving was bad based on, or can we show that he's impaired based on his driving? Well, here Mr. Akima had a burnout light bulb. You can't really say that his driving was bad based on burnt out light bulb. And then what they try to do is they try to equate your inability to do the field sobriety test and say, oh, since you can't do these monkey see, monkey do ballerina test, you must have been impaired. Now, this is real important. If you're a lawyer watching this, you got to write this down. You got to go to the 1998 San Diego NHTSA study. Go to page 28. It's going to be on the 2nd paragraph. And it's that 2nd paragraph, the government who runs these field sobriety tests and who approve them says the inability to do field sobriety tests on the side of the road does not mean you're impaired for driving. So even though government recognizes you can't do the field sobriety test doesn't mean you're impaired. There's a lot of reason why a person can't do field sobriety tests. Overweight, bad knees, bad hips, you just get older. And actually, these tests are not approved for anybody over age of 65. There's no studies because you get older. I mean, look at your grandma and grandpa. They can't hardly walk and they're sober as a church mouse. They're not going to be able to do field sobriety tests. So let's go back to what's happening in the court. The court's looking at would a reasonable officer, would they have arrested Mr. Akima? The short answer is the court said no, and they're allowing for the lawsuit to go forward. But in the lawsuit, the officer, mainly her lawyers, putting up these arguments saying, you know what? the officer had the right to arrest Mr. Akima because he didn't have his driver's license. So they're really fishing for anything that would allow them to arrest him. And if this was in California, there's a case, City versus City of Lago, that says, hey, even for an infraction, you could arrest somebody. But let's go back. They're saying that, hey, we arrested him because he didn't have his driver's license. But the court looked at the video, and in the video, they're asking for his driver's license. He produces his international, and he says, well, it's in my car. And they prevent him from going back into his car and getting his regular Michigan driver's license. On that fact alone, the government said, since you stopped him from going and getting and retrieving his driver's license, we're going to say that that's not a valid reason to arrest him. Then the government goes into the second phase. Is there qualified immunity for the bad arrest because you thought the arrest was valid based on what you saw on the field sobriety test, the breath test, etc.? The court went on to say, and they looked at a lot of stuff, and in the video, they looked at the dispatch logs, and the court paid a lot of attention to some of the statements the officer made. And one of the statement was, I don't know. And the officer also made a statement that I really don't know what I'm doing. I paraphrased that last one, but that was on the dispatch. There was also testimony. It was another officer, Officer Jamie, testified that the officer being sued did not administer the field sobriety test correctly. The judges are looking at the totality of the circumstances. They're saying, hey, let's look at what did the cop have in her mind? And they're saying, well, what was in her mind is that she thought the field sobriety tests were invalid. The clues were there that said Mr. Akima was impaired. However, they recognized in order for this test to be valid that you have to administer them correctly. And Officer Jaime said she didn't do them right. So that gets thrown out the window. Then they're saying, well, can she arrest him because of the misreading? And they said a reasonable officer would not have misread that. They also looked at the fact that she only had 6 months of under her belt at this time. And the court ultimately concluded, and they said, it would be evident to a reasonable officer that Akima was quite apparently sober, thus no qualified immunity. What does that mean at this point? Well, it just means that now they're going to talk money. The lawsuit's going to go forward. If they want a trial, they're going to have a trial, or they're going to settle out of court. Now, you got to remember what happened to Mr. Akima. He gets arrested. He's here on a work visa. He gets called back. He's got to go back to Japan. When he goes back to Japan, he loses his job. He has to go through alcohol education training in Japan. He lost a lot. If he's a high-tech worker here and he's here working on engineering software, then, that's a pretty good gig here in the United States for him. He lost a lot. And again, the 6th District Court of Appeals, and again, what do we have? We have the lower court. They said, yep, there's no qualified immunity. You could continue suing her. Her attorneys appealed it to the 3-judge panel. They even said, yep, you can still sue him. And it's going to move forward. Either this will go to trial, we'll follow it at that point, or it's going to settle out of court. I'll keep my eye on it. Again, Attorney Patrick Silva, have a great day. Hit the subscribe button.